The absence of Justice Bolaji Olajuwon of the Federal High Court in Abuja has stalled hearing in the suit filed by Dr. Bunu Alibe and Mr. Ayodele Olojede, two aggrieved directors of Green Energy International Limited, against the firm's chairman, Professor Anthony Adegbulugbe. The news agency of Nigeria, NAN, reports that Olajuwon had on May 17 fixed Tuesday for report of the out-of-court settlement, which the parties opted for, or hearing of pending applications. However, the matter listed on the cause list could not proceed on Tuesday due to the absence of the judge. NAN gathered that Olajuwon is a participant in the ongoing 3-day judges seminar holding in the National Judicial Institute NJI Abuja. Alibe and Olojede had turned down the interim agreement proposal suggested by Adegbulugbe in the dispute over the ownership of the company. Alibe and Olojede had, through their former counsel Adegbulugbe son, filed a motion on notice marked FHC ABJ PET 2020 against the company and Adegbulugbe as first and second respondents, respectively. NAN reports that Adegbulugbe was a former special advisor on energy in the Olusegun Obasanjo administration. The plaintiffs had in the suit, which was commenced via a petition, accused Adegbulugbe of a series of corporate misdemeanors, including unilateral usurpation of executive responsibilities, contrary to the provisions of the Companies and Allied Matters Act, CAMA 2020, and the company's articles. They claimed that they were unlawfully removed by the chairman, Adegbulugbe, of the company they jointly nurtured to fruition. The applicants averred that such decision was contrary to the provisions of CAMA 2020 and the organization's article of association. Responding, Adegbulugbe also filed a separate suit against the two directors. Although the matter was formally before Justice Ijoma Ojukwu, the case was however reassigned to Olajuwon following the transfer of Ojukwu to the Calabar division of the court recently. When the matter came up before Olajuwon on November 2, 2021, the parties indicated interest to settle the dispute out of court, prompting the judge to adjourn for a report on the out-of-court settlement or for the continuation of hearing in the matter. However, at the February 3 hearing, the new counsel to the two directors, Etigwe Uwa-san, told the court that he had just taken over the matter from Adegbulugbe and would need more time to study the brief. The application was not opposed by Bembela Anichebe San, who is the counsel to the respondents, and the matter was adjourned for parties to explore out-of-court settlements. Upon resumed hearing of the case on May 17, Anichebe recalled that the court, on the last adjourned date, directed parties to explore out-of-court settlement. He said both parties agreed to engage an expert valuer who drafted an interim agreement that would be binding on the parties. He said the agreement was sent to the petitioners on the 27th or 28th of April for them to either sign or comment so that the settlement could be reached and their salaries paid. He said on their own part, they received the draft interim agreement on April 27. According to him, during exchange of correspondences between the two counsel, there was an issue as per manner of evaluation or modus to be embarked on. Responding, Uka, who said he agreed with Anichebe that the matter was scheduled for a report of settlement, however, disagreed with him on his prayer for the petition be dismissed. He told the court that they received the letter and the draft interim agreement from Professor Bolahan Elias, who was appointed to draft the terms of agreement. To show readiness to amicably settle out of court, he said they accordingly responded to that letter. He said his client, however, would prefer a substantive agreement if the parties were willing to come to a consensus. "Did you put that in the letter?" the judge asked. Uka responded in the affirmative, saying, "Pertinently, our clients demanded all outstanding remunerations from the company which they jointly funded." Olajuwon had then fixed June 7 for reports of settlement or hearing of pending applications. However, due to his absence, the matter has been consequently adjourned until June 15 for report of settlement or hearing of pending applications.